Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Joining us for this post-decision episode of SCOTUScast, Penalties and Payback Edition. I'm your host, Bridget Flaherty. On June 5th, 2017, the Supreme Court decided Kokesh v. Securities and Exchange Commission. In 2009, the Securities and Exchange Commission, SEC, alleged that Charles Kokesh had violated various securities laws by concealing the misappropriation of roughly $35 million in various development ventures dating back as far as 1995. Since the 1970s, the SEC has ordered disgorgement in addition to monetary civil penalties in its enforcement proceedings. In effect, the violator must not only pay monetary civil penalties, but also disgorge the profit he or she gained by the unlawful action. Under Title 28 United States Code, Section 2462, however, a 5-year limitations period applies to an action, suit, or proceeding for the enforcement of any civil fine, penalty, or forfeiture when the SEC seeks monetary civil penalties. In Kokesh's case, the district court concluded that the 5-year limitations period did not apply to disgorgement. The U.S. Court of Appeals for the 10th Circuit affirmed, holding that disgorgement was neither a penalty nor forfeiture within the meaning of Section 2462. As a result, Kokesh could be required to disgorge the full $35 million, with interest. By a vote of 9-0, the Supreme Court reversed the judgment of the 10th Circuit. In an opinion delivered by Justice Sotomayor, a unanimous court held that disgorgement, as it is applied in SEC enforcement proceedings, operates as a penalty under Section 2462. Thus, any claim for disgorgement in an SEC enforcement action must be commenced within 5 years of the date the claim accrued. And now, to discuss the case, we have Janet Galeria, who is Senior Counsel for Litigation for the US Chamber Litigation Center at the US Chamber of Commerce.
I will start with a brief review of the facts of the case and then turn to the Supreme Court's decision and its significance going forward. When Congress created the SEC in 1934, it gave the SEC authority to investigate violations of the federal securities laws and to bring enforcement actions if it discovers evidence of wrongdoing. Initially, the SEC's statutory authority in enforcement actions was limited to seeking injunctions barring future violations of the securities laws. Beginning in the 1970s, however, the SEC successfully persuaded federal district courts to order disgorgement in such actions. In general, disgorgement is a type of remedy that requires defendants to turn over the proceeds of wrongdoing to the government. In 1990, Congress authorized the SEC to seek civil monetary penalties in enforcement actions. Congress provided for several tiers of penalties, depending on the nature of the conduct and the losses it caused. However, the SEC continued its practice of seeking disgorgement. As a practical matter, disgorgement is the most significant of SEC remedies. The SEC seeks disgorgement in the majority of its enforcement actions, and in 2016 alone, the SEC collected over $2.8 billion in disgorgement payments, as compared to less than half of that amount in civil penalties. In this case, the SEC brought an enforcement action against Charles Kokesh, alleging that he violated federal securities laws by misappropriating funds from 4 business development companies. After a jury returned a verdict in favor of the SEC, the district court ordered that Mr. Kokesh disgorge approximately $35 million, of which approximately $30 million was the result of conduct that occurred more than 5 years before the SEC's complaint was filed. Kokesh argued that the disgorgement order must be set aside under 28 U.S.C. Section 2462, which provides, except as otherwise provided by Act of Congress, an action, suit, or proceeding for the enforcement of any civil fine, penalty, or forfeiture, pecuniary or otherwise, shall not be entertained unless commenced within 5 years from the date when the claim first accrued. The SEC responded that actions for disgorgement are not subject to this 5-year statute of limitations. The agency argued that disgorgement is remedial, not punitive, and therefore it does not qualify as a civil fine, penalty, or forfeiture. The 10th Circuit agreed with the SEC and held that the 5-year limitations period doesn't apply to disgorgement. The court explained that disgorgement is not a penalty because it merely leaves the wrongdoer in the position he would have occupied had there been no misconduct. And the court reasoned that disgorgement is not a forfeiture because Section 2462 uses that term to refer to an in rem procedure to take tangible property used in criminal activity. The 10th Circuit's decision conflicted with an 11th Circuit decision holding that the 5-year limitations period does apply to SEC disgorgement. Kokesh filed a petition for certiorari asking the Supreme Court to resolve the split. Interestingly, the Solicitor General agreed that certiorari was warranted, and the Supreme Court granted review. On June 5, 2017, the Supreme Court issued a unanimous decision reversing the 10th Circuit. In an opinion by Justice Sotomayor, the court held that SEC disgorgement operates as a penalty under Section 2462. As a result, the 5-year limitations period applies when the SEC seeks disgorgement in enforcement actions. The court began its analysis by articulating 2 broad principles. First, whether a sanction represents a penalty depends on whether the wrong sought to be redressed is a wrong to the public or a wrong to the individual. Second, a sanction operates as a penalty only if it is sought for the purpose of punishment and to deter others, as opposed to compensating a victim for his loss. Applying those principles, the court concluded that SEC disgorgement constitutes a penalty for 3 reasons. First, it's imposed as a consequence for violating a public law. As the court explained, when the SEC seeks disgorgement, it acts in the public interest to remedy harm to the public at large, rather than standing in the shoes of particular injured parties. Second, the primary purpose of SEC disgorgement is deterrence, which is a classic goal of punishment and not a legitimate, non-punitive governmental objective. Third, in many cases, SEC disgorgement is not compensatory. Disgorged profits are paid to the district courts, and the district courts have discretion to determine how the money will be distributed. Some disgorged funds are paid to victims, but other funds are dispersed to the United States Treasury. The court rejected the government's argument that disgorgement is not punitive because it simply returns the defendant to the status quo ante. The court noted that disgorgement often leaves defendants worse off because they may be required to disgorge more than the amount they ever obtained. For example, in SEC v. Contarinas, the Second Circuit held that an insider trader who trades on behalf of another person or entity using funds he does not own, and thus produces illegal profits that he does not personally realize, can nevertheless be required to disgorge the full amount of illicit profit he generates from his illegal actions. Similarly, lower courts have held that a tipper may be required to disgorge his tippie's profits, regardless of whether the tipper received any benefit. Finally, I want to quickly flag footnote 3 of the opinion, which states, "Nothing in this opinion should be interpreted as an opinion on whether courts possess authority to order disgorgement in SEC enforcement proceedings, or on whether courts have properly applied disgorgement principles in this context." In this footnote, the court expressly left open 2 important issues: whether disgorgement is available at all as a remedy in SEC enforcement actions, and if so, whether courts have been properly applying disgorgement principles in those actions. During the oral argument in this case, a few members of the court questioned whether courts should be ordering disgorgement in the first place, since there is no express statutory authority for the remedy and there's no deep historical basis for it. It's possible that one or more of the justices requested this footnote to leave the door open for future defendants to challenge the threshold issue of whether disgorgement is an appropriate remedy. The Supreme Court's decision has significant implications for the SEC and those it regulates. The decision makes clear that the SEC may seek disgorgement only of those proceeds obtained through violations occurring within the 5-year limitations period. The ruling is especially significant in Foreign Corrupt Practices Act cases where the government has obtained massive disgorgement settlements, including $350 million from Siemens in 2008, $177 million from KBR in 2009, and $161 million from Alcoa in 2014. One reason the SEC was able to negotiate such large settlements was it could threaten to file lawsuits pursuing disgorgement going back forever, with no statute of limitations. The ruling in this case should curb such settlements by limiting the SEC's ability to bring actions or negotiate settlements for claims outside the 5-year limitations period. The decision has significant implications for other federal agencies as well. Like the SEC, numerous other agencies rely on disgorgement to obtain major monetary awards against defendants, and many of these agencies enforce statutes that are subject only to the limitations period of Section 2462. Although the court's holding is limited to SEC enforcement actions, its reasoning likely extends beyond the SEC to enforcement actions brought by other agencies, including the CFPB, EPA, FERC, FTC, and FDA.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.